Good morning and welcome back. I'm Deirdre Mulligan. I'm one of the co-directors of the Algorithmic Fairness and Opacity Working Group at UC Berkeley. And I'm really pleased to invite you all to join me on a conversation following up on our first roundtable on facial recognition with advocates on the ground who had been looking at and moving forward in various ways around refusal of facial recognition technology. And today, I'm just going to pull up a slide here. I'm delighted to turn us to part two, which is putting the current moment in some historical context. We have a terrific group of scholars today. Priscilla Regan, professor in the Schar School of Policy and Government at George Mason University. Simone Brown, associate professor in the Department of African and African Diaspora Studies at the University of Texas at Austin and research director of Critical Surveillance Inquiry with Good Systems, a research collaborative at the UT Austin. Colin Bennett, professor of political science at the University of Victoria in British Columbia, and Sarah Ego, Andrew Jackson Chair in American History, Professor of Law, Professor of Political Science, Professor of Sociology, and Director of the American Studies Program at Vanderbilt. I could not think of a better group of scholars to pull together to reflect on and help us kind of connect and pull threads through this particular moment that we're seeing around the refusal of facial recognition technology. They weave together Colin's work, who's studied privacy advocates, and we know that there's privacy advocates in this moment, but there's also a whole range of other advocates and social justice organizers and communities that are coming together and really interested to think about the ways in which the shifting coalition, shifting advocacy, organizations and shifting tactics are playing into the possibility in this moment. Priscilla Regan's work on legislating privacy provides some really interesting insight into successful legislative coalitions that have pushed back on in favor of privacy or to limit surveillance. And I'm really super interested to hear from Pris about her perspectives on this moment. Sarah Ego, her work on the history of privacy in modern America, the known citizen, I think provides this very kind of long overview of how privacy has ebbed and flowed and our interest in it in relationship to different data collection techniques. And I'm super interested to hear how she puts this particular moment in perspective. And then Simone Brown, I think one of the most foremost thinkers who's pulling together theory from surveillance studies, Black feminist scholarship, to reflect on the Black experience and kind of its centrality in our understanding of surveillance. So I just can't think of a better group to have us really try to understand and get our arms around why this moment is so potent and powerful and what's shifting. And with that, I'm going to end my slides so that we can be more fully in a round table. Hopefully my slide share just stopped for you all. And I'm going to open it up with an invitation to Sarah. I wanted to note, so Nikki Ozer of the California ACLU in our first roundtable shared this short video from their archive about resistance to surveillance in the 1970s. And I was hoping you could share a bit about the history of protests around unauthorized image captures more broadly, because I know that's been a part of your research. So please take it away. And you all have the capacity to screen share.
Okay, great. I will do that in a minute, I hope successfully. But let me just start off again, Sarah Igo here. And I just wanted to thank Deirdre and Zoe Kahn for the logistics and the invitation to participate. I wanted to say that it's been really invigorating to be privy to the refusal discussions this past year. and that these discussions have really been a kind of hopeful entry in these unsettling times. So I wanted to, on your invitation really, Deirdre, to offer some reflections as a historian, and specifically a historian of the shape of US privacy debates over the past 150 years or so. And one simple thing to say is that privacy debates, discussions, attention to privacy itself is never simply a reaction to a new surveillance tool or technology, but comes from much broader political and social ground. So I'll speak to that very briefly in my 5 minutes or so now, but it's something I just wanted to place as a kind of reminder for our entire discussion. Mine will be looking mostly backwards, but in thinking about what the conditions are today that make possible certain kinds of refusal and resistance to surveillance technologies. I'm going to screen share here real quickly. I have just a couple of slides. Make sure I can do this. Okay. And are you seeing something there now? Let's see.
Not yet, Sarah.
Not yet? Are you seeing anything? Oh, okay. Okay, it's telling me that screen sharing has failed to start. Sorry.
Okay, hold on a second.
Okay.
Let's see.
It may just be my technological black thumb.
Now, let me just make sure that you are in fact a co-host.
Okay.
Zoe. It says you should be a co-host. Do you want to try again, Sarah?
Sure. Yeah.
Sorry.
Let me go back and try this again. Okay. All right. And if I can't get these to show, that's also fine. Okay. Let's try that.
Yes.
Now you're seeing something. Okay. And now let me just get the slides to start. Okay. All righty. There we go. I wanted to begin, and you asked me about surveillance in the 70s, Deirdre, which I know came up in this earlier discussion and was really interesting to hear the ACLU intoning about the surveillance society that had emerged in the early 70s. This is a period that I think many of us turn to as a useful precedent to our own moment, this period from about the mid-60s to the mid-70s. It was marked by technological innovations. You see some of them here. That threatened to probe more deeply and powerfully into individual lives. And in this case, that was computerization and the movement of identifying material into data banks, but also hidden bugs and wiretaps and things of that nature. But really computer data banks as the key culprit. But I want to point out, and this refers back to what I said just at the outset, is that it was an era of awareness about technological innovation, but it was also a moment of government scandal, of civil rights turmoil and social justice work, of deep distrust in established gatekeepers like the FBI, the draft board, as well as credit bureaus and financial institutions for discriminatory treatment of minority groups. So in many ways, I think that period echoes our own. In the late 60s, half a century ago now, the problem was data capture and secret and unaccountable record systems. This is a moment in which those problems are really first widely debated in the United States. And the era gave, I think, a very resonant name to this problem, a very 70s name, maybe, the records prison. The historical conditions of the 60s and 70s, grassroots activism, scholars and critics, as well as technologists, were able in conjunction to pry open a window for action by the early 70s for sure. And this would lead to new norms and regulations and legislation around privacy, the Fair Information Practices and the Privacy Act of 1974, most notably. Those would also be in certain ways failures or subject to failures. And I just want to mention one of those, that the Federal Privacy Act was silent about what one critic memorably described as Big Brother in civilian clothes, by which he meant the extent of data collection and abuse by private employers, banks, insurance companies, telecommunications outfits, and marketing firms, all of which had helped to create this crisis around personal data. And this moment or opening for action by concerned citizens, activists, and policymakers. So that's one moment, and I think it is the one we often turn to, but I want to take us back even a bit further in time, back to the late 19th century, which was another moment of disruptive technological change, complete with massive private entities that conveyed, bought, and sold personal information. Again, just hearing that, I hope, suggests some of the parallels to our own moment. And I want to talk about this for just a couple of minutes because some of the most interesting debates in this period took place over unauthorized capture of personal images and raised the question of ownership over one's very own face. And in that way, I think is a clear line to today's crisis around facial recognition technology, which is really our subject for today. So photography came out of portraiture, and it was originally envisioned as a way to dignify the individual. And in interesting ways, I think we still see this embedded in a way, and maybe in ironic ways, in the term facial recognition rather than facial tracking or something like that, or facial identification. Recognition suggests something more than just being identified, but being recognized for who you are. And in that way, maybe plays to this longer history. It's a misnomer, I think, as we all know, because facial recognition does not, in fact, dignify typically, but instead tracks, and often tracks inaccurately and in discriminatory fashion. But it did call to mind for me the remarks by Tawana Perry in one of the previous installments of this discussion, and her call to be seen rather than to be watched. At any rate, I just offer this slide of another aspect of capture that photography made possible. Not just the capture of a unique personality or something like that, but the possibility of capture and arrest, really, of one's image. Photography will quickly become a technology of capture in order to identify or to entrap or ensnare. And it comes out of, in this case, dreams of new kinds of legibility and visibility that come with the invention of photography. This slide shows the French photographer and balloonist Nadar, who is credited with taking the first aerial photograph in 1858. But as we know, photography quickly becomes marshaled for the purposes of criminal identification in the mugshot and criminal composites and things like rogues galleries that are already afoot by the mid 19th century. All of these images, by the way, are from the great piece by Alan Sekula, Body and the Archive. And there's just really early enthusiasm for photography and its possibilities to extend the eyes of the police. This is following early experiments in France. In its very timing, photography comes online, if you will, with the quote unquote sciences of phrenology and physiognomy, and the attempts to pin down criminal types by looking at the surfaces of the body to reveal inner character. And so photography begins making an appearance even in texts in criminal jurisprudence by 1846. But there's another history too here surrounding photography and the capture of image, and that is the image captured not for police identification or for security, however imagined, but for profit and sale. And this is what I want to focus on in just the last part of my remarks. Photography had once been slow and cumbersome. Subjects had to sit for a photo. They couldn't be caught unawares. But the arrival of what contemporaries called instantaneous photography in the 1880s meant that picture taking no longer required a cooperative subject. So things like amateur photography take off, the Brownie camera shown here, inexpensive, lightweight cameras that anyone could use. It became a kind of craze of the late 19th century, as does surreptitious photo taking by those called Kodak fiends. You see the marketing and wide distribution of smaller and disguised cameras in this period, and even a market for what were called detective cameras, cameras designed to capture people's images when they were unaware. There will be protests against these virtual invasions, and it would lead to certain kinds of restrictions on the use of cameras at the White House, for example, as well as on public conveyances like trains and ferries. But it will also lead in interesting ways to lawsuits, and lawsuits really over the ownership of one's own image. The brazen use in particular of individuals' images by photographers and journalists and advertisers for profit would trigger what one historian has called the crisis of the circulating portrait of the 19th century. In many ways, these invasions would be the groundwork for early privacy rights claims and the very first law review pieces about a modern right to privacy in 1890. Some of these first right to privacy suits in the United States were brought by individuals, usually women, whose images were used without their authorization to advertise products. One early case is the woman on the left here, Marian Manola. She was a stage actress who was photographed in tights and who would bring suit for the unwanted circulation of her image. She was fined to be in tights on stage, but not in front of a wider public, and sued for that right. In 1902, the woman whose profile is there on the right, Abigail Roberson, lodged a similar complaint in New York against Franklin Mills Flower. She cited the making of 25,000 lithographic prints, photographs, and likenesses of herself without her knowledge, which were then displayed in stores, saloons, and other public venues. And in fact, Abigail Roberson had only learned of this advertising campaign when she glimpsed her own face on a neighbor's bag of flour. She claimed, Roberson, again on the right, she claimed great distress and suffering, having lost control of her image. So Roberson initially won this case in court, despite what the judge noted was the newness of the claim, the right to privacy, which was being introduced in 1902. The fact that she won this case on a very novel kind of claim spoke, I think, to the offense that the new traffic in personal images caused. But the case would be overturned, and the grounds on which the judge overturned Roberson's victory, I think, are telling too. He dismissed what he derided as the so-called right of privacy for its preposterous claim, and these are his words, that a man has the right to pass through this world if he wills without having his picture published, his business enterprises discussed, his successful experiments written up for the benefit of others, or his eccentricities commented upon either in handbills, circulars, catalogs, periodicals, or newspapers. What the judge suggested was that in a mass-mediated world, a world of invisible virtual capture through new technologies, perhaps there was no feasible claim to one's own image, no way of stopping these images from disseminating without one's consent. Much more recently, Clearview AI has issued statements that its facial recognition tool only searches public information available on the internet as is fully protected by the First Amendment. That judge in 1902 and Clearview's comments both indicate what refusal then and now was up against. New technologies and the collecting of identifying information can't be reined in or can't themselves be policed, they suggest, because other public interests are being served by their use, and because the technology for capture is already out there being deployed. Yet that moment of Roberson's lawsuit, I think, is still an important moment of resistance and refusal. The popular outcry over the verdict, in fact, would lead the New York legislature to pass the nation's first privacy tort statute the following year, allowing individuals to sue for the invasion of privacy when their name, portrait, or picture was used without consent for purposes of trade. The questions that this 100-year-old lawsuit raised are ones I think we're still asking. We ask about the control we might have over one's own image, the ability to move through public places unmonitored, versus the public right to see, know, and use material seemingly in the public domain. I think this is an especially important debate to mark right now, given what the sociologist Sarah Brain has noted as one of the most transformative changes in policing in recent years, and that is law enforcement's access to private non-police databases. In other words, the kind of commercial capture of individual images. We also know, given recent reports by BuzzFeed News and others, about the aggressive direct marketing of commercial facial recognition tools to police departments and other agencies like public schools with very little public oversight. So let me just suggest that we will do well to remember and to remind ourselves of the outrage that attended the circulating portrait and the mobilization around the records prison as one background for our discussion of our contemporary dilemmas today. Thank you.
Thank you so much, Sarah.
Let me unshare. Let's see. There we go. Okay.
Great. Thank you. And that seems like a terrific place to segue to Simone for several reasons. In one, I think it's striking that both of the portraits that were up were white women. And, you know, clearly we're in a moment where white women are not the centerpiece of refusal. And I want to note that Tawana Petty, who you mentioned, the National Organizing Director at Data for Black Lives, discussed, as you mentioned, the Detroit community's desire to be seen and not watched. And I think your reflection on like the choice of terms, so often privacy invasive technology, you know, think about total information awareness or Amazon's recognition with a K, they don't do a good job branding. But you know, you're noting here it's facial recognition, not facial arrest, which is kind of perhaps more akin to that records prison that people feel like. And then Mutale Nkonde, the CEO of AI for the People, described facial recognition technology as automated anti-Blackness. And so I think like that the white women resist as the center of resistance is also you know, something that I think is both interesting and very eager to hear. So Simone, I'm wondering if you could position facial recognition technology in relation to historical practices that speak to the Black experience, I think more specifically, such as the Lantern Laws.
Thank you. I'm going to share my screen now. That should work. And
great.
Wonderful. And I want to say, you know, thank you to Deidre and Zoe for the invitation, as well as to the Algorithmic Fairness and Opacity Working Group. It's a pleasure to be here in conversation with my esteemed panelists. So I'm going to start off with this image here. It's from March 2017. That was the time that the Brockton, Massachusetts Police Department held a press conference. They believed that they had a break in 3 cold cases. They took DNA samples found on each of the victims' bodies and sent those samples off to Paragon Nanolabs in Virginia. What Paragon was going to do was produce what they called snapshot DNA phenotyping. So during the press conference, it was claimed that the Parabon Lab snapshot, quote, accurately predicts genetic ancestry, eye color, and skin color, and face shape, but also noting that these are, quote, scientific approximations and not exact replicas. Yet they produced this mugshot looking phenotype report that you see here of a suspect, complete with a map of Africa with parts of that continent's west coast shaded in red. The suspect is said to be 28% European, 57% West African, and some 10% Middle Eastern and North African. At the press conference, the mayor asked for help from the general public, but specifically what he called our large Cape Verdean community. Brockton, Massachusetts is said to be the home of the largest Cape Verdean population in the US. So I still remain troubled by this press conference and the ways that, as they put it, scientific approximations and not exact replicas seemingly criminalize entire populations, while at the same time hailing them to be with the responsibility to catch this suspect. So these are images from Woody Bledsoe's archive that's held at the University of Texas of Austin. So in 1982, Woody Bledsoe, who would come to be known as one of the earliest researchers in AI and facial recognition technology, he was contacted by a defense attorney who was seeking his assistance as an expert witness in a robbery case that had taken up in Northern California. So the attorney provided Woody Bledsoe with a series of photographs, bank surveillance photographs, as well as photos of his client when he was arrested. The bank surveillance photographs were of low quality, as you can see from the image in the center, and key features were obscured, like the ears being covered by a hat, making it hard to, as Bledsoe put it, determine the tilt and rotation angles of the face, and the eyes being hidden by sunglasses. So which made Bledsoe be unable to apply his facial recognition program to assess, for example, interpupillar distance. Instead, he had to do his calculations by hand. And he noted in his file that, quote, we cannot expect to prove that the defendant is a robber, but we might be able to show that he is not. So Bledsoe noted some assumptions around this particular case, and one being that the access of the bank's camera was unknown. I want to gesture to this list of assumptions to point out that when it comes to facial recognition technology by way of executable computer code, some important questions to this day still remain. That being, what constitutes the face when it comes to facial recognition technology? Does the face include cutaneous biometrics through pattern recognition that can assess identity by way of scars or pores or tattoos or wrinkles or other facial markings? Does it include that which stems from the face, like a fallen eyelash? What about effective computing technologies where emotion detection on a live face is used to machine read, so they say, emotions, for example, at an airport, or for monitoring travelers for blood pressure, for fever, for sweat, for body heat, or changes in their voice, and then assigning a threat category or score to that traveler. So these kinds of effective computing technologies heighten the role of affect. And as we know, affect, like race, is socially constructed. And so this should get us to think of who gets marked as angry prior to any reaction. When it comes to the question of what constitutes the face in facial recognition technology, we must also account for long distance iris capture, ear pattern recognition, tattoo recognition, remote measurement of respiration by way of infrared sensors, automated race estimations, and composite profiles like Parabon snapshot that predict faces of an unknown or of unknown persons from their DNA. So a challenge for Woody Bledsoe with this case of the bank robber and his findings was what he called in his notes, the problem of the wider set nose. It seemed the image of the robber captured by the CCTV cameras in the banks had a wider looking nose, according to Bledsoe, around 20% wider than that of the accused. according to his hand calculations. And he couldn't account for this unless the bank robber's nose was somehow distorted by a disguise. Bledsoe admitted in his notes that he was no expert on disguises. His experiments and calculations included using boxers' mouth guards and stuffing his cheeks with cotton. In his notes, he suggested that other than the wider looking nose, the accused looks a lot like the suspect, and he felt kind of helpless, he wrote, working with so little. Throughout his notes, there's a tentativeness at times. He writes that another picture would help and questions, where are the cameras in the bank? And he even posits that with his most careful and conservative measurements, he still couldn't give the robber a wider nose. Importantly, he asks himself, should I continue? Should I continue is a question that we should all ask on matters of surveillance, facial recognition technology, and other AI. So much earlier in 1965, Bledsoe had wrote to the Department of Defense proposing to study the idea of racial background detection culled from facial photographs. Other than that correspondence from the DoD, one could easily surmise that there's little reference to race in Bledsoe's work and in his archive. But race is all around it in the form of prototypical whiteness surrounding whose faces are studied and measured, mainly the pictures of the within his archive. So his archive is held at the University of Texas that I mentioned, and a good deal of it was burned before it was acquired by the university. But from what is there, they're mainly pictures of his white male students whose bodies and facial features served as models of his research. So prototypical whiteness still continues to inform the technocultural logic of biometric identification and verification technologies and even automation in its development and also in its applications. And so by design, a prototypical whiteness, and you can include here, prototypical maleness, prototypical able-bodiedness as well too, undergird certain assumptions regarding the human body once it is made into data and then applied to surveillance technologies like facial recognition or iris and gait analysis. So biometric technology relies on a certain truth claim that the body will produce a definite and certain truth about a person's identity, despite what that person claims. And these types of designs can only work when it relies on the notion that these technologies are infallible, that they're objective, and that a certain mathematical precision or without error or bias on the part of the computer programmers who create data sets and calibrate search parameters, or the analysts who make decisions based on those calculations. And so crucial to prototypical whiteness when it comes to biometric technology is the deliberate absenting of the historical and historically present antecedents, like anthropometry, wide set noses and nasal physiognomy, phrenology, polygenism, and the various et ceteras of scientific racism. And the ways in which this historical precedent is constituted or constitutive of the current biometric technology that we have in our current order. Of course, not everyone falls for this alibi of technological infallibility, and we can turn to the work of the Algorithmic Justice League, as well as the We Won't Build It movement, or the people that take to Twitter to protest when a touchless faucet won't work for them, but it works fine for someone with a lighter looking hands, or when proctoring surveillance software charges them with cheating, or when a pulse oximeter gives me a false reading because of the amount of melanin in my nail beds is unmeasurable to that design. It exceeds calculation. So these are some examples of the refusals, the critiques, the disruptions, and the rebellious ways that seem to answer Bledsoe's question that I think we should all ask is, should I continue? Thank you.
Thank you so much. Wow. We are just pulling in so much history to help us think about where we are and sites of resistance. Colin, I'd like to turn to you next. And I'd love you to reflect on resistance as a tactic among the privacy advocacy community, and in particular, kind of tactics of resistance. In our first roundtable, Tawana Petty again, she flagged the Green Chairs versus Green Lights campaign that is ongoing in Detroit. So this idea of presenting a different narrative of what safety looks like as a way to challenge the idea that surveillance is essential or even supportive of certain kinds of safety, particularly within particular communities. And the emphasis that came out in that first workshop also on kind of narrative and art as methods of resistance. And I'm super interested to see kind of the ways in which resistance in the privacy advocacy community historically is shifting, changing, or as new advocates and resistors are moving in and taking up more space, tactics are shifting and changing. So please take it away.
Okay, thanks, Deirdre, and thanks to my colleagues. I'm very pleased to be part of this conversation. There's a lot there. I don't have any slides. These are going to be some somewhat isolated reflections on the questions. Deirdre kindly referenced my book, The Privacy Advocates, and I wanted to just start with that and talk a little bit about how resistance, or the forms of politics that privacy advocacy network engaged in and engage in now, kind of map onto this notion of individual and collective resistance. And then I'd like to conclude with what I regard as a bit of a success story, at least for now, namely the essential banning of Clearview AI from Canada and how that happened. Because I think it says something about the appropriate relationship and the constructive relationship between collective and individual resistance by advocacy groups, as well as the official regulators who obviously operate in a different space. On the issue of facial recognition, there wasn't actually a lot of it going on when I did that initial research, but I did write a lot about video surveillance. And I recall a group called the surveillance camera players. Do you know these people? They operated in the New York subway, and they performed plays, you know, Shakespeare and others, in little vignettes before the surveillance cameras in order to transpose and disrupt the surveillance technology. Now, I saw that at the time as part and parcel of a broader politics, okay? And I saw that as an example of symbolic politics, okay? An example where important narratives, important actions, important stories, etc., interpret a particular practice and try and connect it to a culture in a meaningful and, in that case, particularly humorous way. But I saw that as having to be integrated with other forms of politics that an advocacy network has to engage in. I got this categorization from a great book by Margaret Keck and Catherine Sickink on transnational advocacy. And information politics, number one, putting important information, relevant information into the policy space at the right time about, for example, the effects of facial recognition technology and its effects on marginalized community, the research stuff. The symbolic politics, connecting all of that to images and stories that resonate within a particular culture at a particular time. Accountability politics, which means creative and important use of the techniques available. I mean, Sarah mentioned litigation, so did Simon, but not only that in this space, also complaints to the FTC, to privacy commissioners. Also something I want to talk about as well, subject access requests. You know, give me my information, delete my information. So there's that accountability politics, using the tools at your disposal in creative ways. And then there's also what I called leverage politics, naming and shaming, okay? using the tools at our disposal in order to, you know, get a company's name out there, get an advocate, get a public agency out there, and leverage pressure. So that's all very high level. But I sort of felt that both individual and collective forms of resistance, and I think at the time, the examples that I were talking about were very, very disparate. You know, there were examples by, you know, Privacy International, but quite disparate. And I saw those as all having to be integrated in a package of political forms of advocacy if surveillance practices were going to be successfully challenged. Now, what has changed in this network? I've done a bit of thought over the last few years about how I would write such a book today. And what has changed, what has not changed, is the nature of the organizations. Many of them are still there, both in the United States and globally. The actual nature, the actual titles of these organizations are very much the same. It's a lot broader, however, and I think all of the activities that I mentioned have been wrapped up in interesting, creative ways, given the scale and the complexity of surveillance technologies. I think there's better funding coming into this network. I think it's a more global conversation and a more global coordination. And I appreciate, you know, that the conversation here is principally going to be about US history and so on, but we have to keep that in mind, that this politics resonates globally. There's better coordination, I think, between civil society organizations, and not only between those organizations that call themselves privacy advocates, but also between the privacy advocacy network, which is large and disparate, and wider civil rights and organizations in a variety of different fields, environmental politics, civil rights politics, and so on. So that's all to the good. And I think also a more creative use of what I call accountability politics, the great example being Max Schrems and his taking on Facebook, okay? So all that comes together, I think, in just a story I'll tell you in the conclusion of my 7-8 minutes, about what's been happening in Canada with Clearview AI. Because Clearview AI barged into Canada without any analysis of our laws, without any understanding of our culture. I mean, it was exactly the kind of thing that had happened in earlier generations with companies like Google. And in a very rapid period of time, all of those forms of politics coalesced in a really interesting way. On the one hand, there was a complaint to our privacy commissioners. Our privacy laws are complex, as some of you might know. They're as complex as those in the United States, if you can believe it. But at any rate, there are 4 commissioners in Canada who have responsibility over the private sector. At the federal level, in Quebec, in British Columbia, in Alberta. There was a coordinated complaint to those organizations which said, you are capturing sensitive personal data without consent in violation of our privacy laws. The company, of course, pushed back and said, oh, wait a minute, this is all out there. This is all public. Commissioners said, no way. Just because it's public doesn't mean to say individuals do not have a privacy right over it. It gets more complicated than that, but the biometric data is sensitive data, and the commissioners pushed back and they issued a very powerful report in February of this year saying that virtually everything that Clearview AI was doing in Canada, everything was illegal. Stop doing it, okay? Secondly, there was a coordinated campaign by civil society organizations, principally a group called Open Media, based in Vancouver, which coordinated subject access requests. So you could go on their website and you could fill out, show me my information, delete my information. And Clearview AI was inundated with these requests, thousands and thousands and thousands of requests, which they were forced under Canadian law to comply with, okay? There is a niggling little issue at the moment about whether or not they're actually deleting images. they will give you your images. And in fact, Simone, one of my students made a subject access request, and she got back from, she's a woman of color, and she got back 2 images were accurate and 3 images that were of somebody else, right? So huge, you know, false positive problems here. But anyway, a lot of that was done. It put them on the back foot. And to their credit, they did in fact respond, but it was all very, you know, sort of pro forma. Thirdly, naming and shaming. Well, Clearview AI had been named and shamed anyway globally, but there was also a campaign to name and shame the police forces in Canada that were using these technologies. And they were on the back foot. That was in Toronto, Calgary, Halifax, and the RCMP. And we knew from FOI requests that in fact they had been using Clearview AI's technology, and within days they said, we're going to stop doing it. Okay, within days they're going to say it was just too toxic. And then combined with that, symbolic politics, media campaigns about inaccuracies, lots and lots of stories about bias against racialized imagery, surveillance imagery, and so on and so forth. So I just tell that story because, you know, it's one of those rare instances, I think, where the official regulatory response and the outside collective and individual resistance converge to a point at which this company was, at least for now, kicked out of Canada. Whatever that means in the global, in the information global. Anyway, they're not operating here, they say. And also there's still some issues having to do with whether or not they have in fact completely deleted all the images and all the metadata associated with those images, and there's ongoing litigation about that. So that's where we are, and I thought that story might be of interest to you guys as to well of the other participants, and I can certainly talk further about that and the other broader political issues in the Q&A. Thanks very much, Deidre.
Thank you so much, Colin. That was terrific kind of exploration of the variety of tactics that were mobilized in this one particular instance as part of the resistance. And I think it's super interesting to think in the US, I think the shape of resistance and the tactics have been different. And I'm really looking forward. I think it's a great place kind of to turn over to Pris. And I would love to hear you kind of both talk about some of the policy instances where refusal has been effective historically, Pris, and what it suggests for you in this moment, given our lack of a privacy agency, given the First Amendment issues that Sarah has already flagged, and I think the very particularized history of automated anti-Blackness that I think people read this particular introduction of facial recognition technology as kind of a historic continuum with. So Pris, please.
Okay, Deirdre, thank you. Thank you to you and Zoe for organizing this. And like everyone else has said, this is a real honor to be a part of the conversation here. I'm going to talk briefly about 4 instances of resistance or refusal in response to technological proposals, innovations. And I'm kind of going to give away my bottom line before I start, which is that in all 4 cases, there are traditional privacy concerns, but those individual privacy concerns were not sufficient to catalyze successful pushback to them. That in order for there to be effective resistance or refusal, the privacy idea needs to be tied to another factor or another impetus. So that's the first takeaway. The second takeaway, and I think this is really relevant when we start talking about facial recognition technology, is to be aware of the backsliding. Because even though in 3 of the 4 cases I'm going to talk about, there was successful resistance or refusal, and then, wait 2 or 3, 5 or 10 years, and it's back again. So the first one is the polygraph. And here, this was, this is sort of the lie detector, what's now referred to as psychological stress evaluator tests. And these raised traditional privacy concerns because of the intrusiveness of the machine, the invasiveness and the relevance of the kinds of questions that were asked, and the disclosure and the interpretation of the test results. So you had this, concern about the accuracy of the tests, which brought in the American Medical Association and the American Psychological Association. And the question of validity came up as an important question. You had a question of legal admissibility here with the polygraph, because there wasn't really enough scientific recognition of it to classify it as expert testimony. So it was not admissible in most courts. And then the last one was a real push by employees and unions, where polygraphs were being used for personnel security screening. And the number of false positives was in, sort of rejecting people that should not have been rejected. So in this case, there actually was legislation that was passed, the Employee Polygraph Protection Act, but notice it's framed in terms of employee protection, Employee Polygraph Protection Act of 1988. And in press reports at the time, this was referred to as the first major piece of legislation backed by organized labor to be enacted in the 101st Congress. So not as privacy, but as, organized labor. In this case, it's still not generally admissible in most state courts, or only if there's stipulation by both parties or if an individual agrees to have it. And it's generally not used in employment except in certain security industries. So this is sort of a success story that is kind of ongoing. The second one is the Real ID Act. And this was a proposal that came out of the 9/11 Commission to standardize the procedures and the formats for state driver's licenses and state IDs, including the photograph, all right, as a piece of what needed to be standardized. This was proposed, as I said, right after 9/11. It called up traditional privacy concerns about a national ID, which we've, at various points in our history, as well as the history of other countries, such as Australia, have rejected. And this, when it came up in 2005, the implementation of it was, of course, going to be done by the states. And there was to this, and refusal. I mean, they use the term refusal to implement the Real ID Act. And only 7 out of the 50 states did not engage in some form of resistance or opposition to the Real ID Act. And partly this was linked to the national ID, partly it was linked to immigration, but most importantly, it was linked to how much it was going to cost to implement it. So this brought in the American Association of Motor Vehicle Administrators, the National Governors Association, the National Conference on State Legislatures, who did these analysis of what it's going to cost. They came up with the figure it was going to cost $11 billion over the first 5 years, and would reduce, God forbid, the effectiveness of the DMV, which everyone regards as ineffective to begin with, and increase the wait time. So this in the press at the time was referred to as a modern Boston Tea Party. And it, you know, sort of, there was indeed sort of broad resistance to it. Now, that was it passed Congress in 2005. You get the state opposition. Then in 2007, Congress passes a law that says, okay, we're going to give $50 million to the states to assist in implementation. And then in 2008, they upped the amount of money that they're willing to give. And then in 2009, 2011, 2013, 2017, 2018, they extend the time frame by which states are to comply with the Real ID Act. But now the Real ID Act is the final deadline. Now they may re-extend it, is October 1st of 2021. So here you've got that kind of, you know, the agent, the TSA and DHS were really persistent in opposing the resistance. And as the cost concerns came down, the opposition sort of, you know, sort of weakened to some extent. So those are both where you have sort of national or state policies. The last two are ones where we don't really have policies. We have more of the kind of collection action and the privacy advocates that Colin was referring to. So this is, you know, the first one is Facebook's newsfeed, which went live in 2006. You had some initial resistance to that, framed in sort of traditional privacy concerns. People were going to lose control over their own information. They were using, in order to do the newsfeed, you know, sort of new, all-powerful and mysterious algorithms to select the info to show. And some of the resistance that came about was the users, you know, Facebook users who revolted. So you had students against Facebook newsfeed, which had over 100,000 members less than a day after the launch of newsfeed. So that, you know, initial, you know, real grassroots resistance. Of course, Zuckerberg responds to that kind of resistance in very Zen-like terms. Calm down, breathe. We didn't take away any privacy options. And, you know, it was the, you know, sort of over time, Facebook users became accustomed, relied on, saw the convenience or the value of newsfeed. So you have this kind of an initial pushback. You have the company responding, and then you've got users kind of accepting, and then you've got the company pushing even further. Google Glass is another instance of sort of resistance and refusal. This came about in 2013 to 2014. And, you know, this is the glasses with the camera, where we would basically have a camera around our face every day. And kind of like, you know, Colin said with respect to Clearview, this didn't just barge into Canada, it just sort of barged in. They didn't do a great job on marketing this or even figuring out what the reason for it would be. It had all sorts of technical challenges that they hadn't thought through. The lengthy battery life, the image recognition capabilities of it were not, you know, up to speed by any stretch, and it collected a lot of data. In this case, it was kind of like, you know, general public resistance, but it was also like, you know, bars and restaurants were, you know, sort of the establishments that said, ooh, we don't want this wearers using this. You know, it was seen in sort of traditional privacy resistance terms, it was creepy. And it was not cool. It was not socially acceptable. And it sort of receded. They kind of took it, you know, sort of off the market for a while. But now it's basically they discontinued it for a couple of years. Now it's coming back in factories where they, you know, people are using their hands. So having that enhanced visual ability is really valuable. And being able to use it in factories has enabled the company to respond to some of the technical challenges so that they're lighter, they're improved in terms of the visual recognition, and they're less expensive. So it wouldn't be surprising if that's another one that sort of slips back in some form or another. So I think in terms of, you know, sort of the facial recognition technologies and the resistance here, those who are resisting have been, I think, have done a lot of things that are really important in terms of trying to have a movement that will not backslide. You know, it's working at the local level and, you know, sort of pressing that pause button at the local level. Getting scientists to, you know, technologists and scientists to weigh in. Getting the employees in the companies to weigh in. And then finally, the social movements and tying it to social justice, which is, you know, basically very much an idea whose time has come right now. So I think I'll pause. I will press the pause button and see where our discussion goes and the kinds of questions that people have.
Thank you so much, Chris. So there's so much richness on the table. I think I'd love to start. So Simone, you framed this really beautifully, the social construction of what constitutes the face. And I think it is very interesting to think about kind of facial recognition as the locus of resistance and all of these other recognition technologies, gait recognition, DNA, all these other things that can basically be used for similar purposes. And you know, we know in many privacy debates, right, there's a bit of this whack-a-mole problem, or in surveillance studies, right, like we beat back one thing to have something else move in. And I was just wondering if we could reflect a little bit both about like why facial recognition qua this particular version of recognition is seeing or is like the lightning rod for resistance, and how we might broaden the discourse to the extent that we think that is the right strategic move. And so I think I would turn to Simone first.
Thank you. Broadening the discourse. Well, you know what Priscilla just said just now about backsliding, it's so important, and that, like, for the example of Google Glass kind of being a test run, and then it goes into spaces where people often don't have the right of refusal, the right to unionize, the workers, these things. And why I want us to, I'll continue to you know, really take up how we think of the face is because when we have these bans or these moratoriums on facial recognition or these stops, you know, there are other parts of that of the face that might not be contained in that ban. And you're right, it is like whack-a-mole. What is the next, thing? And I often look to, artists like Heather Dewey Hagsburg that does, really important work on DNA. And she has a piece that is basically like the parabon, like the finding of the DNA to create some possible, phenotypical type of a mugshot or snapshot of someone. And so I just think it's, always important to be careful. I like to turn to the work of Ursula Franklin and the warning that she has in her Massey lectures, I think from the mid 80s, on the real world of technology and the idea that the state, has to produce this ongoing credible enemy that is cunning, that is just only slightly beatable and the state has to do that in order to excuse or the alibi for this large public, the spending of public goods on armaments, on securitization, on, and now we see we have the public and the private a bit more working in conjunction. And you rightly point to my colleague Sarah Brain's work on predictive policing in the LAPD. And so this idea of the credible enemy, because it's a construction, is not going anywhere. And so because the spending is about to be spent. And so where do we see the credible enemy pop up? Is it, is facial recognition the counter? Is the counter now going to be, heat recognition for like, medical surveillance or pandemic surveillance? And so there'll always be, something. And so while we have to be, careful and perhaps joyous, celebratory of these moves of bans, we also have to make sure that the backsliding doesn't continue to happen, or the front sliding. What's the next thing?
Sarah?
Sure. My brain's going lots of different directions on that question of the face specifically, because also I think, the way much privacy motivated protests have moved is in response to a specific kind of data collecting technology or tool, which is a concrete way to mobilize, and I think it's been extremely effective in the case of facial recognition technology, but only because it's a technology both that has been politicized well by social justice protesters, but also has implicit threat to others, right? So there's something that's working there, along with, I would argue, a kind of deep intimacy about the image that makes it resonate differently than, your credit record. Not to say that people don't care about those records, but I think it grabs people differently. So it makes sense to organize and to mobilize around opposition to that specific technology. But as everybody has already noted, banning facial recognition technology is a victory, but it's possibly Pyrrhic, because there are all kinds of other ways to identify, as we know, and this turn to the kind of the new biometric measures are, there are so many different examples of ways that exist now to track. So it seems to me almost where we need to be thinking is around not specific technologies, but around our procedures for uptake. And this is why I wanted in my own comments to really reflect a little bit on the kind of free rein that has been given to the private sector. And the ways that, of course, that private material is no longer only being used privately. And even if it were, it would be problematic, but it's the kind of porousness between the state policing, law enforcement, and these private actors and private data collectors who have historically had much less public oversight over their work. So something about the order of operations seems to me is important. That is, there needs to be, no matter how utopian this may sound, a kind of public reckoning with these new surveillance techniques before they are enabled, right? And are sort of let loose in the world. And I don't know how we get there. I noticed there was a question in the chat about infrastructures, how we develop the infrastructures for resistance maybe that are that must meet the infrastructures of technology and uptake that are at work in, you know, I'll just speak to US public culture at large, right? The way that these technologies get deployed and are only, and criticisms about them can only be aired after the fact because there's so little public input into their, right, the ways that they get embedded into social practices at large.
Yeah, Sarah, that was terrific. And both Pris and Colin talked about different ways in which kind of institutions might place checks. And I think the story about polygraphs that Pris told, where we had, I think, like both kind of epistemological concerns, like can the technology actually do this thing? But then kind of concerns about, do you meet particular standards to enter our marketplace, right? Is there validation? Is this actually expertise? And the fact that there were organizations and institutions that had some power to act as those checks, and kind of the absence of those with the rollout of facial recognition technology in the public sector, which has been super interesting to watch, right, in the US, the emergence of these different privacy commissions or algorithmic impact assessment, you know, groups. And I would love to hear both Pris and Colin reflect a little bit more about kind of what are the institutional hooks we need to put in place to make resistance possible, not just on the back end. And I think, Colin, you really talked about all the accountability politics that could be pulled in and leveraged after we know something exists. But I think, Pris, you were talking a little bit more about some of the gatekeeping and the ways in which that played a really important role, at least with respect to that one technology. And then I'm going to turn to some audience questions. So Pris and then Colin, please.
Okay, I think that one of the really important as we move forward here in the development of various sort of identity and surveillance technologies is going to be the employees in companies who, if they start to resist the technological, you know, innovations that the company is putting forth, if they see them as sort of, you know, socially unacceptable, if they see them as creepy, you know, that I think is going to be an entree point for resistance that we did not have before. And I think that's mainly sort of the technologists, the data scientists in companies who, you know, become concerned, for example, with the, you know, bias in algorithms and who are sort of pushing themselves for some change. And that really sort of then goes back to, you know, the sort of education and training that data scientists and computer scientists and engineers are getting, and that there be an, you know, sort of ethical component to that, or a social justice component to that. Because I think that generation, you know, that's coming on, one could say the previous generation, that it was sort of like, you know, it was tools. It was mainly sort of, you know, nerds who were really interested in the technology, way the technologies worked, and hacking and finding, you know, it was a game. And I think that new crop, and I may be overly optimistic here, of technologists are being trained differently and don't see it as just a technical game, but see the broader social implications of what's going on, and realize that they and their families and everybody else is going to be, you know, it's part of the world that is being created, the societies that are being created, and it's not necessarily where they want to live. So I think that I'm hoping that's my sort of source of optimism. Colin?
Yeah, I mean, just one basic point here, I guess, is that the resistance to this is a heck of a lot easier if you do have a comprehensive regulatory structure where the face is defined as your personal information unambiguously, and which might only be captured with your express consent. Now, obviously, you know, there's going to have to be exceptions to that, and there are reasonable approaches, etc. But just some reflections on, and I think, you know, that's, you know, I think that's where the conversation is moving in the United States. One thing that I reflect on with respect to the companies that develop these technologies, some of them are incredibly sophisticated about privacy and do lots and lots of work beforehand, but most of them are not. And one of the difficulties I think we find in the discourse is that people who know very little about the subject or pick up little bits of information along the way then use tropes that are somewhere in the privacy narrative, the privacy literature, which they then mobilize in order to justify what they're doing. Number one, a reasonable expectation of privacy, right? You know, how can you object to us using your Twitter image? You know, you don't have a reasonable expectation of privacy over that, you know, that kind of stuff. Secondly, the distinction between public and private. Well, it's out there, you know, and we all know the arguments about all that, but it just gets repeated over and over and over again. It's out there. You don't have a reasonable expectation of that if it's out there, right? And then thirdly, and a bit more subtly, you know, this whole question about the relationship between individual privacy rights and collective privacy rights, which is brought front and center in this issue, you know, and where you really cannot separate out the risks to the individual from the risks to the group. Now, you know, we've been talking about that for 20 years or more. I mean, David Lyon wrote about social sorting 20 years ago, and the Oscar Gandy and all of that literature. But to the extent that the resistance, and this is something that I must say I find terribly difficult to get my mind around, to the extent to which the resistance is framed in terms of this very powerful word called privacy, right? It negates or it diminishes the ability to argue for the group rights and the collective rights. On the other hand, when you talk to average citizens, whether they're Americans or Canadians or everybody else, about what right they think has been abridged by having their image scraped from their Twitter handle and used by law enforcement, they'll come back and say it's a privacy right. Okay. Now, you know, we've got lots of interesting literature, I mean, Helen's work and so on, about, you know, how those two questions should interact. But when it comes down to challenging an intrusive technology like a Google Glass, great example, or like the other ones that I and Chris and others have mentioned, you do confront those problems in the discourse that you first got to overcome before you can get to the right solution.
Yeah, so it makes me, like your comment, Colin, I think makes me really reflect on the resistance that we are seeing to facial recognition technology in the US, where privacy is certainly part of it, but I wouldn't say privacy is the leading. I think it is very much framed in terms of racial justice and social justice and concerns about, right, being over-policed and under-supported, right? Those sorts of things. And I'm wondering for all of you, you know, whether or not you think that shift in emphasis towards concerns with kind of histories of oppression, structural, systemic patterns that I think are much more about collective interests and what does it mean to be, quote unquote, a free and open society, to be a fair and just society, are more resonant right now, I think, like for all the reasons that Sarah talked about in the 1970s. Like, is it this moment of racial reckoning that is actually making it possible to have this conversation in a more meaningful and powerful way? That it's not about privacy?
I'll jump in on that one. I think that is very true. I think it's helpful that that facial recognition is indeed related to something that, people kind of hold, sort of precious, or they feel funny about, or they've got, some sense of, it's that, the woman in Sarah's picture with the tights. She didn't mind being in tights on the stage, but she just didn't want it out there for the public. We have this, sort of odd sense of, how we present ourselves, and want some ownership over that. It's sort of the intimacy of the information and that Sarah just said. But I think that alone, if we just relied upon that, that would not be sufficient, as was true in so many other cases, to get us across the finish line, to get any real opposition to. And I think that, at this moment, but, hopefully even that this will continue, that having this framed in terms of social justice gives it so much more power. And I think it's a social justice. I think it's also combined with that, sort of like, we don't need cameras everywhere. We need to be a community, and community should be able to. Is it the green door? Is that, yeah, I think, that, yeah, at the local level is really important.
Yeah, I love how you framed that question, Deirdre, and I think it's tough because, as Colin mentions, privacy is inadequate to describe this bundle, like this ever expanding bundle of concerns, right, that sit under it. Yet it does sometimes, but often very temporarily, right, mobilize people. So I couldn't agree more with these sets of comments that some of the kind of legacy of past privacy battles and ways that people have learned to think about privacy as, ownership, or as something that belongs to them, that is imperiled, is a kind of, I don't know, substratum, under these things. But I agree, not sufficient, right? I mean, I think it's absolutely clear that the success, at least so far, the success around facial recognition bans has been mobilized almost entirely because of protests against violent policing, which sadly, right, have kept people's attention riveted because of the experience, right, because of this past year and more, obviously, of examples of really violent law enforcement. And that's keeping people's energies and attentions kind of fastened to this issue. And I think, privacy alone wouldn't do it. If you think about the example of, say, airport body scanners or something, right? That be a little blip of resistance and then gets totally normalized. So I think the question, because so much of our debates looking historically over privacy have, there has been outrage that then kind of falls away, is thinking about how, I don't know, how to sustain that outrage, right? How to keep interlocked the kind of broader concerns about privacy, or about corporate privacy invasions. I think that's a piece of what's going on here too, right? I mean, Facebook and Amazon, all the other companies have been treated to a new level of scrutiny over the last few years, and that has combined, right? It's intersected with Black Lives Matter protests and sort of more generalized worries about tracking in all kinds of ways. So. As has a kind of just, I would say, almost society-wide education into the problems of data, that has been one product of a lot of discussion around big data and algorithmic bias and so forth. So I'm always conscious of how many things have to come together, right? And they're not always the same pieces in order to sustain a resistance or a refusal. I think Chris's examples are really interesting because they're all different constellations that enabled, at least for a time, some kind of halt. And the question for me is just how do you keep that going, because there's a kind of politics of attention, I would say here, to privacy disputes.
Simone?
Yeah, I kind of it's a great question, but I was hesitating because, you know, I'm thinking like, where's the retrenchment coming? Where's the pushback? And that the kinds of work that people are doing, organizers, people with the ACLU, and to like the call, Sarah, that you say to keep up that energy, like it's exhausting, you know? And so, it, you know, other people have to take the weight. But, you know, and speaking of retrenchment, you could think about Google firing Timnit Gebru and also Margaret Mitchell, so whistleblowers aren't being protected. So there's always like a blowback, or it's seemingly always so. And so what do we do to protect whistleblowers? You know, you know, students who are, you know, in computer engineering who refuse to even go to those spaces, you know, rather than leave them in the first place. So all of these things, I'm just kind of, you know, wondering about the sustained energy. It has to be collaborative. It has to be collective. And I think that I saw one of the questions, a couple of them asked, you know, what does refusal look like on the ground, so to speak, for people that are organizing, for example, in some type of, you know, processing or distribution center, where you know, labor organizing is curtailed at minimum. And you know, there have been, you know, histories of the people using the weapons of the weak, when James C. Scott or also Harriet Jacobs makes use of the same term. And part of that is about collaboration, is about accomplices, it's about you know, other people in various stages and sites of power acting together for a certain political project or purpose. And I think that's the kind of energy that has to keep up, but also waiting for, you know, that other shoe to drop, because of, to go back to Ursula Franklin again, this kind of ongoing production of the credible enemy.
Yeah, so we do have, just to build on your, both the kind of exhaustion, and Tawana Petty in our first roundtable really emphasized how exhausting this work was, both like on the day-to-day, the work of it, as well as the emotional labor of it, right, being exhausting. And we've had several questions come in that are interested in the infrastructure. And so we've talked about coalitions. We've talked about different sorts of kind of accountability politics, how we might use existing modes of holding people accountable. I'm wondering if, as a group in this last little 15 minutes together, we could reflect on kind of creating infrastructures to make resistance practices sustainable over longer periods of time, understanding that these do tend to be most powerful when they are coalitions. How do we help those come together and find each other? And also, is there a role for academics in this, given that we all are? How do we see ourselves in resistance movements? So Colin, why don't you kick it off, since you are the last?
What role should academics play? Because there are some academics who would say that, you know, academics should be academics and do research and be scholars and not try and change the world, and that we're not very good at it. I don't agree with that, but I like to think that the accumulated effect of research over time can push activists, politicians, regulators in the right direction. In terms of you know, coordination, I'll just say something about the subject access request form of resistance. It doesn't need to be overdone, but it can be quite effective. And I mentioned a group in Vancouver that's been doing this, that whenever they do see something that they don't like, they put up a web form and they say, you know, if you want to get your information from this company or this organization, here's an easy way to do it, right? And all of the various provisions in the relevant legislation are listed, so you don't need to do anything. You just access, you just submit an access. Now that can be overdone, and it tends to anger organizations, and it tends to, particularly for public sector organizations, it can put an enormous amount of stress on underpaid information coordinators and so on. But it is a strategy, and it is being used more effectively, I think. I wanted to say something, I was going to say something in my opening remarks about the appropriate relationship between resistance, both collective and individual, and the regulatory structure. Because I wrote about this, and I've in some subsequent articles, and one of the things you tend to find is that you have an official kind of network of experts in this area right now. They're the regulators, they're the chief privacy officers that you wrote about, Deirdre. And then there's the outsiders, the external people, and they tend to be regarded as somewhat fringe, right? And in some societies, that group is ignored. In some societies, there's open hostility between the regulatory group and the others. There is at the moment between Max Schrems and the DPAs in Europe. There is a more positive, constructive alternative, right? Where the advocacy network and the advocacy group are doing the research, they're getting out there, they're mobilizing, they're informing the public about new technologies and new practices, they're on the cutting edge, but they're also talking, and they're also not constantly in the media complaining about how weak and spineless regulators are, even though that may be the case in some circumstances. So there are lessons to be learned there, therefore, about the capture of regulatory authorities by companies and by governments, which is, of course, we all know a lot about, but also a more credible and a more constructive relationship between the network of outside advocates and resistance and the regulatory structures. And I think that one example I gave you is a perhaps all too rare example where that coalition comes together and where the various components of the network work towards, in this particular case, a good end. And you see other examples as well, but they tend to be somewhat isolated.
Thank you. Why don't we go Simone, Chris, Sarah, because that's how you're displayed on my screen. And then I'm hoping I can get in one last question.
Could you repeat the questions?
Sure. It was about creating infrastructures, right? And also then, to what extent is there a role for academia as infrastructure? And certainly that can be through our research, but are there other ways in which we can be part of?
Yes, got it, yes. And when you first, like, the infrastructure that I create is a syllabi, and we can't necessarily read our way out of these problems, but we could get some background information to understand the stakes and to understand earlier current forms of where these kinds of tactics of collaboration, of abolition, of mutual aid continue to be successful. And I think that's the type of infrastructure, like reading groups, that perhaps I can offer. Others can offer, other means of doing this, but I think the reading groups, whatever group it is, it has to be tied to not only within the universities, but what certain universities are complicit with, being run like a hedge fund, union busting their graduate students or not supporting them, having working towards a certain carceral logic in terms of funders, or the food being made at the same places, or even making the carceral state possible, the prison state possible. And so all of those are connections, I think, that have to get to Mitali's question at the bottom, to make these larger connections. So it's not just about facial recognition, or what's happening to my old Flickr photographs, or my Twitter profile or whatnot, but really what are the larger kind of stakes in this surveillance capitalism, or identity industrial complex, or whatever ways that we want to term this current order that we have.
Terrific. So Chris and Sarah, before you jump in, I was hoping to make Mitali's question kind of the last one. And since Simone has brought it in, Mitali, who was one of our speakers on our first panel, She said in New York, activists aligned with the movement for Black Lives are reading Dr. Brown's article, Visuality, Surveillance, and the Afterlife of Slavery, because the end goal is liberation from all domination, not just facial recognition, not just privacy. We've never had it. And she asked, how can we encourage white allies to find comfort in this framing, right? And how might we shift people to think not kind of reflexively about privacy, but about liberation, about other things that might be end goals, and what readings might we offer to support that shift in orientation. And so feel free to kind of tap into any and all of that as we go through our last comments.
Okay. I think the emphasis has to be not just on creating infrastructure singular, but plural. I think that we really need to be operating at multiple levels and with a variety of tactics. And I think that that is one way of kind of keeping energy going, is that there's different things that you can be doing. You're not just hitting your head against the brick wall in the same way that you had been doing it, but you've got different things. So it's a real multi-pronged approach. I think in the States, in the United States at this point, working at the local level, state level, county level, city level, is easier to organize, and it's more likely to yield sort of positive results in terms of getting change. Hopefully Washington will change and become a place where we actually get policies passed. But for the moment, working at the national level, I think is just fraught with frustration. I think the media is another piece of it that we really need to bring in, to make stories accessible, make the tech reporters, for example, sort of pay attention to some issues. There's a Washington Post reporter who's sort of really kind of taking new technologies that come on board and sort of, testing them out and then running a story about them. And hopefully people are reading it, because most of his responses to these are, wait a second, this doesn't quite work, or this technology is picking up way more information than it's leading one to believe. It's also, I was struck within my own family and my group of friends of the power that Netflix, Social Dilemmas, and the podcast that they did also along with that. It was like, they were like, oh my gosh, can you believe what they're doing? And I'm looking at them saying, you didn't know this? Wait a second. I've been telling you this. But, so I think that is, and that is not, I guess that is something we could sort of do as academics. It's that role of the public intellectual that is, the thought leaders, public intellectuals, that we need to get out there and collaborate with others in the media. And last, and I'm really here reflecting on something that, well, it may not be last, but on something that Simone said, sort of, it's kind of like, politics begin at home, or change begins at home. In our own universities, I was struck by the fact that at many universities, the technology in order to get into the gyms, and the technology to get food is facial recognition, because the students don't want to, or don't always have, their ID. And this is convenient. So once again, we're, sort of bucking up against that, that this is, people like things because they're convenient. They want their privacy, but they also want their convenience. So I think, in terms of like syllabi or reading groups, in and classes to, sort of query this notion of, why are you using the facial recognition technology, but also within, faculty senate and places like that where we could work change on the local level there. I think to the last question, in terms of sort of social justice and will white allies find comfort in the frame? This gets to the debate about how do we talk about how do whites talk about systemic racism, and how do we engage in these discussions? And I think people are there's more sensitivity to it, and I think that framing it in terms of racial justice and also social justice it can be really powerful. So I'm again a little more optimistic that the Black Lives Matter and the sort of overall education that seems to be going on, the reaction, for example, to the Chauvin trial, that all of this is going to be sort of a social change that is long lasting.
Sarah.
I feel like there's so many big and important questions now on the table. Let me offer a couple of thoughts that will necessarily be pretty incomplete. One of them, and this is in response to Deirdre's question, I think first about what can academics do, and it's kind of a vexing one sometimes for a historian, I have to admit. But I actually do think, and this is partly in response to a conversation I had last week with a Vanderbilt colleague about license plate readers. And he said, he was a colleague in the engineering school. And he said something like, well, these technologies are out there. They're going to be used, and there's nothing we can do about it. I actually think a very powerful role that we have is as tellers of stories and of histories about the past, and about the refusals that Chris and Colin and others have mentioned here. And I think we have an important role to play as critics of inevitability theses. At the same time, when I look back at the past, I find it hard to find really hopeful examples of public responses to invasive technologies that really and finally halt them. So there's a complex dynamic there, but I do think making those stories more visible is actually really important. And to suggest that no matter how embedded and inevitable some of these practices seem to be, that there are tools, there's equipment, there's our agency, there are maybe even our civic and scholarly responsibilities, right, to resist them. So for what it's worth, those are my thoughts in the moment. I also do think there are probably structures that we haven't yet envisioned for increasing and making more simple and more accommodating, honestly, to academic time, our relationships with policymakers and advocates of various sorts, and to try to think creatively about where those nodes are, how they might be facilitated, what philanthropic organizations might support them, right, and make it possible to free up, in a sense, the kind of critical research and scholarly time for policy work, I think would be actually a really interesting thing to contemplate on this issue and many others that academics might speak to. To the question about white allies and their ability to partake in a reframing, I think is totally critical. And I think I have some hopefulness about it. I also have some pessimism about it, honestly, looking at the ways that the only moment I can compare it to is a moment in the 1960s, where for a few years, the rights of welfare recipients were really on the agenda for some white Americans, right? That really mobilized to work on their behalf and to make their concerns about privacy invasions visible to a broader public. And you know, it didn't last for that long, that window. And I think we need to be thinking really carefully and critically about how precarious and fragile these windows of opportunity are for real change. And Simone's absolutely right. We can't rely on the, you know, exhausting labor of those on the ground and in the trenches on this issue. But it really needs to happen. So I think this question of coalition building and networks and amplifying these voices is just really critical, and not really an answer, but just a restatement of the problem.
So I want to thank all of you. On the closing kind of question about the reframing, you know, for myself, I think racism is a white person problem, right? I don't want to be an ally. I want to be a full participant in trying to change the way in which we think about the disproportionate burden that our surveillance society puts on the most vulnerable and disempowered. And I think everyone who's here views their role in that way too. And I think this question of how do we create space, how do we create tactics and logics that sustain refusal, and how do we help those who are on the ground doing this really important work, is something that we can hopefully do through reading lists for sure. AFOG, our Refusal Conference, we generated a reading list, and I'd love to add more to that through facilitating conversations with public intellectuals like yourselves that can provide fuel and fodder and support and camaraderie to people who are doing this work. Hopefully, I think, as all of you mentioned, educating students who have a kind of data literacy and technology literacy, that they resist those tropes of inevitability and understand that we socially construct, not just technology construct, as we think about the futures that might be possible. And so I want to thank all of you for joining us and participating in all of those activities that I think are within our kind of our purview. And lastly, this question about policing ourselves, that as universities are adopting machine learning and AI to do all sorts of activities, to really, those are places where we can lean in. I'm currently the chair of our Faculty Senate Committee on Computing and Information Technology, and making sure that these issues are kind of front and center, right? Like, do we always need to be convenient? Depends on what the real cost is there, right? And really elevating those conversations in our own technical choices, because universities, we have enormous capacity to shape the market. So with that, I'd like to thank you all for being so generous with your time during a period where all of our time is so precious and all of our eyes are so burned out from looking at these little screens. It was just such a privilege to be in community with you today. And I want to encourage anybody who's listening, go back and listen to part 1 of the roundtable. It was fabulous. Sarah Hamid, Mutale Nakonda, Nicole Ozer, Tawana Petty, Dunstan Allison Hope. It was really terrific. Go back and look at the panels that we made public from the Refusal Conference, to the extent you really want to really kind of steep yourselves in some of the possibilities and some of the challenges. And with that, thank you to Zoe for all your help with organizing. Thank you to Jenna Burrell, my co-director of AFOG, and thanks to everyone who came to join us today.
Thank you.